5 seconds to go. Start. It is therefore logical to conclude that PW1 would have gone to the police station to lodge the FIR and returned to the hospital for further treatment. The variations indicated in the Tahrir and the FIR, as well as the argument of improbability based on a minute by minute construct by the learned counsels for the appellants, can under no circumstance become fatal to the acceptance of the Tahrir and the FIR. This court, while noting the defects and variations in the investigation observed in Rameshwar versus State of MP, when an eyewitness is examined at length, it is quite possible for him to make some discrepancies. No true witness can possibly escape from making some discrepant details. Perhaps an untrue witness who is well tutored can successfully make his testimony totally non-discrepant. But courts should bear in mind that it is only when discrepancies in the evidence of a witness are so incompatible with the credibility of his version that the court is justified in jettisoning his evidence. But too serious a view to be adopted on mere variations falling in the narration of an incident, either as between the evidence of two witnesses or as between two statements of the same witness, is an unrealistic approach for judicial scrutiny. It is a common practice in trial courts to make out contradictions from the previous statement of a witness for confronting him during cross-examination. Merely because there is inconsistency in evidence, it is not sufficient to impair the credit of the witness. No doubt, Section 155 of the Evidence Act provides scope for impeaching the credit of a witness by proof of an inconsistent former statement. But a reading of the section would indicate that all inconsistent statements are not sufficient to impeach the credit of the witness. A former statement, though seemingly inconsistent with the evidence, need not necessarily be sufficient to amount to contradiction. Only such of the inconsistent statement which is liable to be contradicted would affect the credit of the witness. The trial court has been a super technical approach in doubting the timing of lodging of the FIR for arriving at an erroneous conclusion. The FIR and the Tahrir are anti-timed. In these circumstances, there are compelling and substantial reasons for the High Court to interfere with the findings and conclusions of the trial court. Yet, another substantive argument advanced on behalf of the appellants is that the presence of PW1 at the scene of the offence is doubtful. Therefore, his testimony must be rejected on the ground that he is not an eyewitness at all. To make this point good, the learned counsels advanced fourfold submission, which is also the reasoning of the trial court. We will refer to each of the submissions and deal with them. Based on the statement of PW1 in the FIR that the accused party fired at them indiscriminately, it is argued that this statement cannot be believed as there were no multiple bullet holes on the Jonga. In fact, the Jonga only has one bullet hole on the left side of the windscreen. A proper reading of the evidence demonstrates the following. The head constable M.T. Malkhan Singh, PW4, conducted the technical examination of the vehicle and prepared a report exhibited as Exhibit A2. Though Exhibit A2 is in Hindi and the content of it is available in the testimony of PW4, which we can consider and understand the correct fact situation. PW4 states in the report that the Jonga had a hole in the windscreen window and multiple holes in the back side of the driver's seat. He also stated that there were holes in the upper body of the back tire of the left side of the Jonga and on both sides of the window. The driver's side mirror was also broken. This description matches the seizure memo of the Jonga exhibited as KA-29, which was prepared when the Jonga was seized. The relevant part of PW4's testimony is as under. There was a hole in the body towards back in a left side. Condition of steering was okay. Condition of brake was okay. Condition of back pedal electric light was fine. Transmission was fine. Suspension was fine. Tires were in running condition. There was a hole in the front mirror windscreen window and right side, and there were holes in the back seat of right side driver seat. Driver mirror was also broken. Holes were found in the side doors of both side windows. Holes were not found in the back curtain. Holes of curtains, except one or two remaining holes, are inside the fold of curtain. That which is one or half hole has not gone while folding the curtains from many places. We have carefully perused the seizure memo of the Jonga, which clearly describes कई जगह पर गोलियों के निशान हैं. Stop.